Court officer. Court officer.
Ready, sir.
Am I audible?
You are audible.
Thank you.
A Prop 90 of 2016 is partly allowed. Judgment and decree dated 15/3/2016 in MC number 28 of 2015 on the file of Family Court Dakshina Kannada, Mangalore is partly modified. Wife is entitled to permanent element of rupees 20 lakhs from the husband. The amount of rupees 20 lakhs shall carry 6% interest if not paid within 6 months from this date. RPFC number 49 of 2015 is allowed in part. The impugned order dated 2/12/2014 in criminal miscellaneous number 2 of 2014 on the file of Family Court Dakshina Kannada, Mangalore is partly set aside. The wife is entitled to maintenance of rupees 5,000 per month from the date of the said petition till this date. The order awarding rupees 2,500 per month to the children of the petitioner and respondent in the children attain majority is not disturbed. No rest to cause.
Charges equal to. And then. Click. Don't have. When. For the applicant submits that office objections have been complied with. In view of the aforesaid submission is placed on record. This will proceed further. The applicant time is granted. Next steps was. Yeah, what? Translation of Kannada annexes cannot be necessary. The requirement of you want to file it. Why you are seeking weeks time, madam? Have you not heard him? Current counsel for respondent prays for it. Enable her to prepare the case and argue the same list next week. The order shall continue. Number 5, DTP sufficient. Same order in item. When I say same means same, nobody is appearing that you can do it. It's same order. You have not deposited. Let litigation expenses as well as a year of maintenance be paid within a period of 2 weeks, prevailing which appropriate order shall be passed. Hey. This learned counsel for the applicant prays for the granted 2 weeks time to enable her to comply with office obligations. See for the HR. Office is directed to reflect the name of Mr. Harish Kumar as counsel for comment number 2. And Harish Kumar VL is not appearing. Office is directed to delete the name of Mr. Harish Kumar VL. See for the HR. Okay. So what you need weeks time is granted to comply with office of.
11. University RB.
Order if any.
11. University RB.
For the appellant, let office objections. Right. For the appellant, despite 4 it is being granted, the appellant has not chosen to comply with office objections paragraph. Let office objections be complied with within a further period of 2 weeks, within which appeal shall stand dismissed.
Number 12.
Both the cases. What's your name? The appellant submits at the office objection. Like with in view of offset. Is directed to proceed.
Number 13. Mark Terry.
Time is granted.
Number 14. Abhishek Kumar.
In PGV, the counsel for the appellant. As the offset. Like the appeal is dismissed as before.
16.
A memo line 16, a memo has been filed seeking leave of the court to withdraw the appeal. The aforesaid memo is taken on record. Line below in the result appeal is dismissed as before.
Abhishek.
This one is the next time. We will need to comply with office.
18. Karinayan.
Weeks time. Missing the counsel for the petitioner undertakes to comply with office objections during within 1 week. 1 week notice on behalf of respondent. Respondents is accepted by Mr. Hegde. The praise fund is granted. Weeks time to enable it to file status.
Number 19. Shiv Kumar.
By 4 of none copy despite 4 opportunities being granted to the office objections have not been complied with. Line below let office object each and dismissed without prejudice.
20. Haryana.
Current counsel for the respondent is granted a week's time to enable him to file YA1 of 23 line bill. The parties jointly submit that the dispute between parties is likely to be amicably settled and they are willing to appear before the Bangalore mediation center such date as may be fixed by this court. Paragraph 2 of aforesaid submission are directed to appear before the Bangalore mediation center on what date? June. June not thereafter. to appear before Bangalore Mediation Center on 3rd June 23 at 3:30 p.m.
आइए
Heard on IAN application seeking condonation delay for the reasons assigned line below, for the reasons assigned in the application form fully supported by an affidavit, we find that sufficient cause for condonation of 106 days in filing the application of substitution of legal representative of the appellant is made out. Like also heard on IA2 of 21 for the reasons assigned in the application format to be supported by an affidavit, abatement of the appeal is set aside. Also heard on IA3 of 21 application seeking substitution of the last of the response. Appellant approval. For the reasons assigned in the application format in this affidavit. No, the says the drugs of diseased appellant number 1 are permitted to be brought on record. Paragraph. The line below in the result IA 1 of 21, 2 of 2 of 21, and 3 of 21 are allowed. Let amended cost has to be filed within 1 week.
case Mahadevan. Please, Dayanandra.
They have filed an IA for withdrawal. Have any objection? What a simpliciter withdrawal, right? Yeah, they have filed a memo for withdrawal of the appeal. With no, what happens if the appeal is withdrawn? Can they not do it? Okay. There's nothing to ask your client about. We will not say if they are well within their rights to appoint an evaluator, the permission of the court is not necessary, right? Why should you seek adjournment? Let it be decided today itself. We take it up in password. Please wait.
23. Okay.
Made counsel for this appeal. This appeal. You are contesting that she is not entitled to permanent delivery. After all, I mean, she's your daughter. You are not paying anybody to anybody else but your daughter. She doesn't need money. No, this is 10 lakhs to the minor child. No, who is that? You will hear it at leisure. No hurry. Learned counsel for the appellant states that. Just wait. No hurry. Learned counsel for the appellant submits that the child, that the daughter of the parties, namely Miss Shreya, has already attained the age of majority, and therefore the issue with regard to her guardianship does not survive for consideration in this appeal paragraph. The aforesaid submission is placed on record. Learned counsel for the appellant submits that the appellant is challenging the order only insofar as it pertains to grant of permanent alimony of rupees 10 lakhs to the minor child. What grounds you can challenge? No, you wonder, Mr. I mean, what we are telling from here, just listen to us. We will admit it, no problem. We have plenty of time. We can hear any time. But no. What we have seen is that in most of the couples may have, I mean, severe differences of opinion and they fight like anything. But when it comes to the child, they say, no, sir, I have no objection. She is my daughter. I will pay. You are the first parent in 2 years who is objecting to this amount of 10 lakhs, which is granted. Fine. Let him appeal. All right, so there's nothing like appeal is admitted to be. This is that the record. Appeal has already been admitted for hearing. And let the same be listed for final hearing in its turn. In usual course. Yes.
24.
So where is the counsel for other side? Oh, not appealing. But on IA 1 of 23. What is that, Mr. 23C? Taking into account the should memorize it by now. We will punish you if you don't tell us. In view of the mandate contained in section 21B, capital B, within bracket number 3 of the Hindu Marriage Act 1955, IA 1 of 23 is allowed. Let the appeal be listed for final hearing on 7th August 23. This is none for respondent to serve, right? Then this order. That you should without me telling.
Yes.
Adjourn. How much? You want adjourn? Oh, we thought that you will oppose it. That's why we were keeping quiet. Otherwise, any other counsel we would have said, we thought that you will sternly oppose. That's why we were keeping quiet. Okay. Mark the presence heard on IA 1 of 2022 and application seeking continuation delay line below for the reasons assigned in the application form duly supported by an affidavit delay of 237 days in filing the appeal is condoned in the result IA is allowed. What is this? Current counsel for respondent praise fund is granted. How much time? 10 days time to enable him to file objections to IA 2 of 22 list week after next.
Number 23.
By experience. Thank you. Yes. Yes. So busy day for Mr. Reddy. So next week then. Huh? All right. Vivek Super Reddy, then have counsel. Learning. What's your name? The counsel correspondent, praise for short accommodation. List in the next week. Clear. Huh? Okay. It's June. What you tell us the date? We come to report every day. Huh? What's the- What date? 8th June 20.
About 27. The attended by government educate. 15 years. Yeah,
Also, supposing your grievance is confined only to the fact that you will have to approach what admission and overseeing committee, no? No, that's correct, but where should you approach? What is, we will grant you the liberty. You should approach the admission overseeing committee, right? To seek refund of fee. Is it not? We will say so. We will modify the order passed by learning single judge. We will say that you will be at liberty to approach the admission overseeing committee with regard to grievance of refund of excess fee, and we will request admission overseeing committee to. All right. After what notice was issued, right? No, but this, we have entertained it only on this ground that grievance pertaining to refund of documents have been returned to you. What else do you want? Then you want a refund of amount along with interest at the rate of 25%. Correct? Mr. Bhatt, on 15th February 23, we have recorded your submission and has issued notice. You are now arguing something else. Please speak. Please speak. If it's wrong, then we will recall this order. If this is wrong, then we will recall the order. Correct? Then, so did they file this thing? Objections? Did you file objections before the learned single judge? Did they file, Mr. Preliminary hearing itself? Yes, Mr. What do you say? Who appears for respondent number 3? What? Why you should not? His admission has been cancelled or whatever. He has got the documents back. But what about fee? Huh? What happens to the bank guarantee that has been discharged? What? They have not filed this thing. We will have to set aside this order before they file rate petition to contest. Right? Correct. They have not filed objections. This intra-court appeal is filed against an order. Mark everybody's present. I need not repeat this. Everybody's present, right?
Is in favor of this. Wherein liberty is in accordance with the respect of the favor of this defense.
This claim for this thing has to be decided. Not everybody is present. This intra-court appeal is filed against an order dated 12th of February 2020, passed by learned single judge, by which writ petition preferred by the appellant has been disposed of. Paragraph. The paragraph we have heard learned counsel for the parties at length. The writ petition, the petitioner, the appellant had made the following reliefs. So, page 19. Paragraph. Learned single judge, however, no. Paragraph. When the matter was listed for preliminary hearing, learned single judge, without awaiting the return from the respondents, by an order dated 12th of February 2020, has disposed of the writ petition. Full stop. While disposing of the writ petition, learned single judge, though has directed return of documents to the appellant, yet has not adverted to the prayer made by the appellant for refund of fee. Full stop. The entitlement continuation, the entitlement of the appellant to refund of fee has not been adjudicated, and the same cannot be adjudicated in this intra-court appeal in the absence of any statement of objections on behalf of contesting respondents. Paragraph. For the aforementioned reasons, order dated 12th of February 2020, passed by learned single judge in WP 54625/2016 is set aside. The learned single judge is requested to adjudicate the controversy involving the writ petition afresh after affording an opportunity of hearing to respondents to file statement of objections if they so desire. The appeal is disposed of.
Matter number 22.
Bill number 28, I appear for the respondent, my lord.
22, sir.
And for the appellant, even when the matter is called in second round. So, and 123/20. An application seeking leave of this court to withdraw the appeal. The aforesaid CA company application is taken on record. Line below, the appeal is dismissed as withdrawn. Well, where has he gone? Where has he gone? Yes. But he should have been here, right? Yes. Madam, you are appearing for intervener.
Bill number 28, my lord.
Please come this side. Since yesterday you are standing here, that gives an impression that you are an intervener, neither for the husband nor for respondent wife. Please come here. Please. It's written no respondent. Here, did you see this? Sure. There. Respondent. So we were confused since yesterday that you are appearing for intervener, nobody is appearing for respondent. Yes.
Twenty-eight appear for the respondent.
Huh?
28 serial number.
What is it like? Claim that it's your self-acquired property and purchased in the name of wife. So you should have claimed the whole of the property by half. Huh? Ah. So you are for the wife. That's why you so much readily agreed, right? You're wondering that how come a counsel in Bangalore has agreed with the submission made by the court within less than 15 seconds. Then we realize that we are speaking in your favor. At times, then also counsels don't agree, even when we speak in their favor. Pleasant surprise that you agree. Yes. He said.
I request my lord to kindly take the date. More particularly, page number 5 of this list is where code, where paragraph of
Page number?
5, page number 5. Last time.
Paragraph?
It is unnumbered number after paragraph number 13. Last time.
Page number 5. That's how it starts.
ಪ್ರತಿವಾದಿಗೆ ದಿನಾಂಕ 30/4/2023. Already kindly taking the ತಿದ್ದುಪಡಿ ವಾದ.
Yes. Which paragraph?
After paragraph 13 minus
Yes, prayer.
ವಾದಿ ಘನ ನ್ಯಾಯಾಲಯವನ್ನು ಪ್ರಾರ್ಥಿಸಿಕೊಳ್ಳುವುದೇನೆಂದರೆ ಘನ ನ್ಯಾಯಾಲಯವು 1ನೇ ಪ್ರತಿವಾದಿಗೆ ಈ ಕೆಳಗೆ ಶೆಡ್ಯೂಲ್ ನಲ್ಲಿ ನಮೂದಿಸಿರುವ 1ರಿಂದ 7ನೇ ಐಟಂ ಸ್ವತ್ತಿನಲ್ಲಿ ಒಟ್ಟು ಕುಟುಂಬದ ಸ್ವತ್ತಿನಲ್ಲಿ 3/4 ಅಂದ್ರೆ ಮುಕ್ಕಾಲು ಭಾಗ ವಾದಿಯ ಹಿಸ್ಸೆಗೆ ಪ್ರತ್ಯೇಕವಾಗಿ ನೀಡಬೇಕೆಂದು ಹಾಗೂ ವಾದಿಯ ಸ್ವಾಧೀನಕ್ಕೆ ಮೇಲೆ ನಮೂದಿಸಿರುವ ಶೆಡ್ಯೂಲ್ 1ರಿಂದ 7ನೇ ಐಟಂ ಸ್ವತ್ತಿನಲ್ಲಿ ನೀಡಬೇಕೆಂದು 1ನೇ ಪ್ರತಿವಾದಿಗೆ ಆದೇಶಿಸಬೇಕೆಂದು ಮತ್ತು ಉಳಿಕೆ ಕಾಲು 1/4 ಭಾಗ 1ನೇ ಪ್ರತಿವಾದಿಯ ಜೀವನಾಂಶಕ್ಕೆ ಇರಿಸಿಕೊಳ್ಳಬಹುದು ಎಂದು 1ನೇ ಪ್ರತಿವಾದಿಗೆ ಘನ ನ್ಯಾಯಾಲಯವು ಆದೇಶಿಸಬೇಕೆಂದು ವಾದಿಯು ಕೋರುತ್ತಾರೆ ಹಾಗೂ ಶೆಡ್ಯೂಲ್ 8ನೇ ಐಟಂ ಭೋಗ್ಯದ ಮೊಬಲಗು ₹4,25,000 ಪ್ರತಿ ಮುಕ್ಕಾಲು ಭಾಗ ವಾದಿಗೆ 1ನೇ ಪ್ರತಿವಾದಿಗೆ ನೀಡಬೇಕೆಂದು ಘನ ನ್ಯಾಯಾಲಯವು 1ನೇ ಪ್ರತಿವಾದಿಗೆ ನಿರ್ದೇಶನ ನೀಡಬೇಕು. ವಾದಿಯು ಈ ಘನ ನ್ಯಾಯಾಲಯವನ್ನು specifically thank you. So he share. That's wrong. Item number 8
So item number 8 is with him now. Item number 8 is with the husband. Tenant.
He has contributed for payment of the money. The operating portion, my God, kindly see. Clearly, those money beyond the relief has been found. And this is said in the participation, there could be a share that will be declared. So what the operating portion now says, page number 44 of the agreement, it is partly degree. The plaintiff is entitled for half share in items to the plaintiff. Dependent number 1 instance will hand over the taking position of items within 2 months from the date of partial. Now there is no prayer for recovery of position of property. Not
Seven are all vacant sites.
item number 3 to 6 have already been given in prayer to filing of the suit.
3 to
3 to 6.
alienated.
Already
Filing the suit.
before filing.
Fear of whom?
Start my favor created.
Alienation in favor of whom? Third party or
One is in form of a sale deed, two in form of gift.
son is made a party.
This is made up. One of the son is made up. The other son is not. Another kindly see under page number 3 of my synopsis. Have given my dates on which some of the two properties were alienated. Third, item number 6 has been sold in favor of Nagraj on 9/9/2010 for a valuable consideration of 3,38,000. Exhibit D2 is the document. Likewise, my lord, item number 4 in favor of Naveen, one of the son of the plaintiff and defendant number 1. And Naveen is not a party to the in his favor, my lord, on 26/5/2011 for a valuable consideration of 3 lakhs, which item number 4 has been sold, and it is at exhibit D. As far as defendant number 2, Naveen is concerned, it is also asserted. The gift deed has been executed on 2/7/2011. And my lord, the said documents have been marked as exhibit D6. So item number 3, 4, 5, and 6 my lord, were not available for partition. My lord,
Just tell me which is item number that is transferred to Naveen.
my lord, nothing but item
Number 4. Nagraj,
Nagraj item number 6.
item number
6.
6.
Praveen item number 3, item number 5.
5, 6, yes. 7.
7 is a
Deal with you.
item number 2 my lord, is a site. Item number 1 they have not disputed. Item number 8 is a rented. Now these has
Not disputing his income. They're not disputing the income of the husband. Was it?
Now the question that
So if he was not contributing, how will you survive? If he was not contributing, ready to pay the income tax return? In 1999. When the properties are purchased,
have given the details of all the properties have been purchased on various. Item number 2 is the this number 2 money.
No.
Item number 1 on 25/3/2010 for valuable consideration. Exhibit B can be given. Now item number 3, my lord, for 1 year and 9 months, exhibit B. Item number 4, 1 year and the very same day, 9/11/1990, for 18,000, exhibit B5. Then my lord, item number 5, Muhammad Hussain Shah, on 14/5/1982 for 2,000. In fact, item number 5 is purchased on the same day from the same person for a consideration of 2,000. Item number 7, my lord, is 10,000. This is how the
What was the income declared?
year after year, my lord, it has changed. My lord, as far as exhibit B is concerned, 52,587 is the income that I have declared from the tailoring. Much before the
So which year?
this, my lord, is for the year 2005-2006.
5 and 6. 2,000 is the annual income. Gross.
It's a gross income.
Then?
Fact remains, my lord, that she was an income tax assessment, and she said that she was receiving the rental income, also, my lord, the income from the rent. And that is the document available from exhibit B.
Rental income from which property?
Pardon?
Rental income from which property?
My lord, it's the Tumpur property. That is, my lord, item number 7 that will purchase me.
Which year?
Item number 7 that will purchase in the year
83.
1883 for 10,000. It's a house property that I'm deciding.
1983, you are not income tax assessee.
Those parts, my lord, are not good. But the fact remains, my lord, it's purchased. And I was saying, my lord, the property.
83, husband was working abroad. 83, husband was working abroad. Husband was working abroad in 1983.
Not like was extraordinary in his education. That's he was my lord, a real something that could suffice to maintain. Now the question is whether we had on behalf. This would be one question. That his wife happened to herself. My lord, herself.
The property would come into picture provided it is given to her in a limited way. Yes.
Some of the sentences, my lord, that I sentences I have noted on that and just go.
No, are you disputing the jurisdiction of the family court to contain a suit for partition?
Not now under section 7, family court will be used concerning the properties which belongs to the parties. That alone. Now, if the foundation itself is the joint family property available for parties, typically saying that I'm related to that. Well, this is gone into by the family. Mostly,
Where they have said it's a joint, where the
but I read the fair paragraph. Okay.
out from the government of the
And
plaintiff.
our
The plaintiff government says that it's his property. Where what he says is 1/4 is to be given to the wife towards maintenance.
now, lying to he says, what to kutumbada swastinalli
Pick up that one word. Plaintiff has to be read in a whole. The entire plaintiff argument says that he was working abroad, he earned the money, he contributed or he paid the money to purchase the property in the name of wife. Only in the prayer column he says 1/4 is to be given to the wife towards maintenance. Some sort of concession he has given.
That concession. That is where my first line of submission is contention that I have raised. In these kind of things, when he is saying that I have purchased the name of the wife, he must seek the now a partition will not succeed. Because he is saying that I want a share in the property. Now, until and unless he gets the declaration to take possession by paying the adversary policy, I mean, he cannot inoculate throw me out of the property in a manner now for today. I quickly run through my the contentions that I have noted in my synopsis without taking much of my time.
Here to argue, we have to write a judgment. Nobody is hurrying up. No, asking the question means we are asking you to conclude. Please don't be under that impression. Otherwise, we will have to keep on sitting silently. Asking question doesn't mean that we are asking you to close the case immediately in 2 minutes. Nothing like that. Please argue the way you want.
But my first contention is for partition in subject to making without taking exploration of title that the plaintiff was there, the property was not maintained. And I'm not taking the plaintiff by surprise. In fact, in my written statement, I have specifically contended. Paragraph number 13. Paragraph number 13, and I have said that it is submitted that under the facts and circumstances created by the plaintiff and the contentions taken by the defendant 182 in the statement, the plaintiff ought to have instituted the suit for declaration of the title over the suit properties and for recovery of possession by paying court fee on the market value of the suit property and not otherwise. Therefore, the court fee paid by the plaintiff on the release of partition is not. This is what has. In spite of it, really good. The second contention, suit for partition and separate with property, which the plaintiff himself calls as not property. Now I have going to read line number 2 of as being a hundred. And there is not say that the second definition loan is not given. There are two other children remaining. Nothing in detail. Was not created because the family court decision only those properties belong to the party. Now, even assuming my that we take this, that since these properties were purchased in the name of the wife, the dispute between the wife and husband should be gone into by the family. As on the day of the filing of the claim, my lord, items number 3 to 6 were not in the hands of the defendant and the one counsel. Now, two properties which have been received by defendant number 2 cannot form, my lord, a subject to be resolved by the family court because the son is not a marriage, is not a party to invoke the jurisdiction by filing this. And hence, when it's right away, item 3 to 6, without much of its difficulty, marriage must be excluded from the party because that was not available even in the hands of the as well. Now, my lord, this is the case. Three court against bank, three court has sought over the two property. Now, the reason is that has been given by the family court to give one offset page number 43 of the page.
Yes.
But I will kindly permit it to read 6 from the top, starting from the word moreover. Moreover, the plaintiff is really one court shares the scheduled property towards maintenance fee of the month. Even though the we were taking care of the mother of the and also brother and purchase the property to the thing. But then says I want to put there on the detail. I reduce it out.
So observation is in your favor.
In my favor. It could have been complete because of invoking 46(1). I have taken care of it. Now, now I have 16 editions. That you organize have taken a few. Purchased in the name of the wife, then it will appear.
Range it is all right. Instance of white.
In the instance of the wife, I was meted out with cruelty number. And number two, he was having he was spending more money for wedding. He was specifically observed on these things. Hence, having regard to this fact, entire God, in my respective was loss of the property of the wife. And ultimately, where he might series initiated against the wife. So here is a he wants the wife to pay. Then one has wanted to purchase property. And the property belongs to him. That may not be correct.
Refer to section 7 related to jurisdiction.
I compile the synopsis that are coming. Page number 9. The division sentence. Paragraph number 17 commences with the extract of section 7. Page number 9. After it is extracted from paragraph number 15, Clause A of subsection 1 of section 7 makes it clear that the family court will have jurisdiction and proceedings of the nature referred to in the scheme. Therefore, unless it falls within one of the categories referred in the scheme, the family court gets no jurisdiction. Clause C of the explanation deals with one such category of suit or proceeding between the parties to a marriage, the property of the party, or of either. Clause C of explanation 7 typically deals with property dispute. The dispute should be relating to the property of the party or of either of them. For family court to exercise jurisdiction, two conditions must be satisfied. Firstly, the dispute between the parties to the marriage only, and secondly, the property of the party or either of them. Both these conditions can take cognizance or proceedings under the act in respect of the property. Therefore, it is clear that family court has no jurisdiction to entertain and write to or proceedings paying a property by going other than the party, further the property belongs exclusively to the party or either of them. Questions other than parties are the family.
You are trying to say is purchaser is not a party to the marriage. Sons are not parties to the marriage.
One of these
Correct.
is property by the family.
Because they knew it'd be going ahead, no? The matter, just ask them to send it back with the person who's coming back to office. Okay. That's
Okay. Four, five, six. So in any case, in respect of properties 3, 4, 5, and 6, it is without revision.
Item number 1 we have considered. Item number 8 is not available because it is a rented. That leaves only one action. Item number 7.
One what consider.
One we have considered that it's the actual property. Though he sought share in the property, we have taken a defense in mind. But we are not concerned with property.
It needs what?
It must be the property that we had taken on rent in my city. There is no degree my lord, as far as I can see. Only to the extent that since the marketing was given by him, it is also intended to be when he comes.
It's 7.
Going straight my lord to item number 2 and 7. Item number 7 is purchased in the year 1983 for rupees 10,000. 1983 on 9/5/1983, defendant number 1 purchases property from one Brahman. For a consideration of property. Property is a house property. That's
3 and 5. Item number 3 and 5.
also Indian.
Those Praveen is made a party.
Is made up. That is 9.
Restriction of the court in respect of these two properties also not excluded. Not a party to the not a party to the marriage. Yes.
Now I need to answer on the earnings of the husband to the contribution he has made for the person. That might not be thinking.
Yes.
Number 8.
Yes.
Next paragraph. Now, why? So he doesn't have any record to create conflict. He doesn't know when the property is coming. No, this is not a very good deny property. Then it's done. Okay. ಸಾಗರಕ್ಕೆ ಖರೀದಿ ಮಾಡಿದ್ರು. ರೈಲ್ವೆ ಗೇಟ್ ಬಳಿ 2 ನಿವೇಶನ ತಲಾ 6,000 ರೂಪಾಯಿಗೆ ಖರೀದಿ ಮಾಡಿದ್ರು. ತುಮಕೂರಿನ ಅರವಿಂದ 2 ನಿವೇಶನ ತಲಾ 5,500 ರೂಪಾಯಿ. This amount that he mentions is totally
Second son is with the husband. Wouldn't she says he
then what happens is it becomes very difficult to come to conclusion.
he needs to show that he has transferred the money from him. Which it is perfectly well.
ನಾನು ವಿದೇಶದಲ್ಲಿದ್ದೆ. ಪೇಜ್ ನಂಬರ್ 9. ನಾನು ವಿದೇಶದಲ್ಲಿದ್ದಾಗ ಮೊದಲನೇ ಪ್ರತಿವಾದಿಗೆ ಆಸ್ತಿ ಖರೀದಿ ಮಾಡುವುದಕ್ಕೆ ಪತ್ರ ಬರೆದಿದ್ದೇನೆ ಮತ್ತು ಸದರಿ ಪತ್ರಕ್ಕೆ ಮೊದಲನೇ ಪ್ರತಿವಾದಿ ಉತ್ತರಿಸುತ್ತಾರೆ. ಸದರಿ ಪತ್ರಕ್ಕೆ ಯಾವುದು ನಾನು ನ್ಯಾಯಾಲಯಕ್ಕೆ ಹಾಜರುಪಡಿಸುತ್ತೇನೆ. There was such a letter that was written by him directly to the property on this behalf. And I have replied and also stated that I am doing so. He should have produced it. Now then I say why it is not produced. That shows my this is that would have produced. Yes, foreign adverts. Page number 10, the 11. First, that this was an affair with the wife of Ganga, and that God
Is it after his return or before he went to abroad? Huh?
Page number 11, paragraph number 2.
Is he a witness to one of the sale deeds? Item number 5. Suggestion to that. Effect. There is suggestion. Yes.
Second. That is the identification about the wife of Gangaram. Then he says, it was the daughter's wedding of that Gangaram. But he is a man. Person who was sending him the email. Working. Four lines. Only one medical
Yes.
Then marketing can be next page number 30. Second paragraph, 6 lines from the top. Start from this Dava Yelene items.
Yes.
Yes.
The income tax. Now, all so I couldn't
purchase the property is something that has been. But as far as he is concerned, hold it was. But I myself. No.
So item number 6 is sold. Ah, yes. Yes.
Yes. Because when we take all these things, so very sleepy. So we have to confirm. He is feeling very sleepy, constantly yawning. So we will hear you a little later. We should hear him properly. He is constantly yawning. Your counsel opposing you online. He is feeling sleepy. The
Paragraph. Cross examination. When the daughter was married? C-17. Yes. Yes. Item number 2, purchase for how much amount? 60,000. Item number 2 is Tumkur, no? Which is Tumkur property? 7. That was purchased in 83. For rupees? Enter income.
The income that I have declared. Overall, not purchase the name of Prema, who is the mother of Prema. Then they will again market. From
So class section 14, two things, news in possession. The property will be given to him as an limited owner. It's not the case here. So that's why it's honestly. So because section 14 is
I want a remand. Draw that application, additional evidence. Draw that application.
there a right or the property is dependent on that judgment? How does it affect the
In a
property?
partition position where your husband was having an affair, is it material?
How are you relying on section 14? Section 14, was allowed thinking. Applies in a situation where the property is given to a lady with limited right. Is it your case? That the
Submission is independently of section 14, you are an owner.
Yes.
Abu Bakar Shafi, sir.
Here for the respondent, my lord.
Yes.
The suit filed by the plaintiff, that is husband, my lord, for partition and separate portion of 3/4 and permanent injunction from alienating, my lord. The marriage celebrated between me and the defendant, first defendant. I was the plaintiff. That is on 2/2/1976, my lord. And from the marriage, we had 2 sons, 1 daughter. Now the first son is 33 years, second son is 29 years, and daughter is 23 years. And Lord, I was working at the time of marriage, that is marriage in 1976. And from 1974 to 81, I was working as a special technician in Mangalore Chemicals and Fertilizers. And from 1981 to 86, I was in Libya, my lord, as a technician, that is chemical, some specialization, my lord. With that, I had been to Libya, 81 to 86. There, I used to receive the salary in pounds, my lord. And from 4,750 UK pounds per month. And from 1991 to 10/8/1991 to 31/8/1991, I was in Qatar. And from 22/4/1995 to 4/5/1996, I was in Dubai, my lord. And I earned sufficient money and sent my portion of earning to my wife because I had the credibility. And she has purchased a property in Mysore from my money. She has purchased a property in Mysore and in her place Tumkur and in Bangalore also. That is from my earnings. From my earnings. And after the retirement, I came to India. Now I am almost 70 years old and with all serious diabetes and hypertension and heart problems. Now, because I became waste to my family and I was thrown out and I was taking shelter with my relatives, my lord. And these people, my wife and children, are enjoying and selling property. And my lord, I totally rely on, and whatever the trial court given judgment, partition of equal share, that is acceptable for me, at least to survive for myself, my lord. And your lordship may kindly see from the judgment of the trial court, that is para 24 onwards, my lord. Para 24. Now, I strongly rely on the judgment number 50%. Okay, equal share is okay for me to survive for myself. Otherwise, I am virtue because entire my life I send everything to my wife to purchase, and now I am on the street, my lord. Your lordship may kindly see para number 24 onwards. Para number 24, my lord. Admittedly, till the filing of the petition for divorce by DW1 against the plaintiff, the mother of the plaintiff was residing with DW1. The evidence of PW1 stating that since he was working in abroad, the properties were purchased in the name of the first defendant could not be ruled out because DW1 had no any independent source of income to purchase several properties. The evidence of DW1 stating that her father has financially helped her to put up construction of the house and she has put up construction out of her earnings is far from truth. DW1 has not stated as to why the plaintiff was not giving money to her even though he was working in abroad. Exhibit D1 is the certified copy of the registered sale deed for having purchased item number 7 of the scheduled property in the name of the first defendant. Exhibit D2 is the certified copy of the sale deed which discloses the first defendant has sold item number 6 of the scheduled property to one Nataraj on 9/9/2010 for consideration of rupees 3,38,000. In the sale deed, the reason for sale is shown as to meet the legal necessities. What is the legal necessity is not forthcoming in the document. Exhibit D3 is the certified copy of the sale deed for having purchased item number 6 of the scheduled property in the year 1982, which has been sold as per Exhibit D2. Exhibit D4 is the certified copy of the sale deed dated 26/5/2011 for having sold site number 42, that is item number 4 of the scheduled property, to the elder son of the plaintiff for consideration of 3 lakhs. This property sold in favor of the son of the plaintiff has been purchased on 9/11/1992 by DW1 as per the certified copy of the sale deed, Exhibit D5, paragraph 25. The documents produced by DW1 disclose that she has purchased properties during the 1980s and 1990s and only one property in the year 2004. Exhibit D10 is the original sale deed for having purchased item number 2 of the scheduled property by the first defendant in the year 2004. As per the evidence of PW1, there was an agreement to purchase the property 10 years prior to the purchase of of same in the year 2004. This cannot be ruled out because item number 2 of the scheduled property site measuring 30 by 40 feet, which is situated at Bangalore North Taluk, was not available for 60,000 during the year 2004. But it is several lakhs worth property. DW1 in her cross-examination has stated that her first son Naveen paid her sale consideration of rupees 60,000 to purchase item number 2 of the scheduled property. That's in Bangalore, Lord. Even though DW1 was receiving rentals from the house property situated at Tumkur, she never contended that she purchased item number 2 of the scheduled property from her earnings, but has stated that her son gave money to purchase the property. No materials placed by DW1 to show that her son gave money to her purchase property. In fact, during the year 2004, DW1 was receiving rentals from the house. In spite of it, she has not stated that she purchased the property from her earnings, even though the property has been purchased for rupees 60,000. When the plaintiff was driven out of the house at Mysore, which was taken on lease, the plaintiff has issued notice to the first defendant as per Exhibit P1 on 30/4/2011, for which DW1 has issued reply notice as per Exhibit P2 on 12/5/2011, stating that she is busy with the marriage of her daughter and so she requires 1 month time to give detailed reply, and immediately DW1 has executed gift deed. Immediately after that, my lord, executed gift deeds in favor of her son, that is the second defendant. Since the first was in abroad, DW1 has executed gift deed in favor of her one son. Subsequently, the second defendant has executed gift deed of the item number 3 of the scheduled property in favor of his elder brother on 18/5/2013. As per the certified copy of the gift deed dated Exhibit D9, the evidence of DW1 discloses that she has sold one of the properties in favor of her first son to meet the marriage expenses of her daughter. So her son sold to meet the expenses of her daughter marriage. DW1 never contended that he had money to perform the marriage of her daughter, but stated that the plaintiff has not helped her to perform the marriage of her daughter. In fact, DW1 has sold the property in the year 2010 for sale consideration of rupees 3,38,000 and sold another property in favor of her first son for rupees 3 lakhs, which discloses that DW1 has performed the marriage of her daughter by sale of the properties of the plaintiff and not out of the earnings of DW1 or by borrowing loan. DW1 has stated that the plaintiff has not performed the marriage which was held in the year 2011, but never stated that the plaintiff has neglected to maintain her and her sons and daughters. If DW1 was maintaining the family out of her earnings, she would not have kept her mother-in-law with her till the filing of the petition for divorce by her. Para 27, my lord. DW1 has produced the income tax returns for the years 1999, 2000 to 2005 to 2006 marked as Exhibit D 11 to 16. In all the returns, more income shown is from house property and meager income from business, that is from tailoring, which is very meager, amounting of rupees 1,000 to 4,000 per month, that too in the year 1999-2006, my lord. As per Exhibit D 11 to 16, DW1 has just submitted reports, but she is not an income tax SSC and has it's just report. She is not an SSC and has not paid even a single rupee as tax. DW1 ought to have produced the income tax returns for the years 1980 to 1996, the period in which she had purchased properties, and for the year 2010 till the adducing of evidence, during which period she has sold the properties and got income from the properties. As per the income tax returns exhibits D11 to D13, the assets of DW1 is shown as site and house at Madhugiri, but none of the scheduled properties are situated at Madhugiri town. In the income tax returns exhibits D14 and D15, the location of the sites and house property is shown as Tumkur, and in exhibit D16, in the income tax returns for the year 2005-2006, the site situated at Bangalore is not shown. In the original sale deed for having purchased item number 2 of the scheduled property as per exhibit D10 on 25/3/2004, the address of DW1 is shown as resident of Basveshwar Nagara of Bangalore. But as per the income tax returns for the year 2004, the address of DW1 is shown as resident of Mysore. DW1 has not stated that she was residing at Bangalore at any point of time. Now, para number 28, Lord. If really the scheduled properties are the self-acquired properties of the first defendant, he would not have executed the gift deed and sale deed in respect of the scheduled properties immediately after the receipt of the notice from the plaintiff. DW1 has no right to execute sale deed or gift deed in respect of the scheduled properties, and the same is not binding on the plaintiff. DW1 only to defraud the plaintiff from claiming the scheduled properties, she has executed gift deed and sale deed in favor of her sons. DW1 has vacated the house at Mysore, which was taken on lease without intimating the plaintiff. If really DW1 was giving tuitions and going tailoring work, it was not possible for her to suddenly vacate the house at Mysore and shift to Tumkur. In fact, DW1 in her income tax returns has not shown her income from tuition. DW1 had taken the house on lease consisting of 2 rooms. Admittedly, the plaintiff was using one of the rooms as his office and was running the company. But nowhere it is stated that DW1 was using any of the rooms for tailoring or to give tuitions to the children. PW2 is the mother and PW3 and 4 are the younger brothers of PW1. The evidence of PW4 is discarded since he has not been tendered for cross-examination. PW2 and 3 have clearly stated that DW1 was not doing tailoring and giving tuitions to the children, but all the properties have been purchased out of the earnings of the plaintiff. The evidence of PW2 discloses that she was all along residing with DW1, and after the construction of the house at Tumkur, they have shifted from Madhugiri to Tumkur. If DW1 has purchased a site out of her earnings and she alone has constructed the house, the family of PW2 would not have shifted from Madhugiri to Tumkur. Para 29 law. DW2 is the stepmother of DW1. She, in her evidence, has stated that she married Timmappa Rao, that is, the father of DW1 in the year 1974. And she is the second wife of Timmappa Rao. The first defendant married the plaintiff in the year 1976. The first defendant is the daughter of her husband through his first wife. As per her evidence, her husband was doing tailoring and employed 2 and 3 employees and doing cloth business under the name and style of Sulake at Mandipet, Tumkur, and he was getting good income. As per her evidence, DW1 was doing tailoring work and giving tuitions to students and getting good income, and her husband also helped DW1 to purchase site at Vidyanagara, Tumkur, and to construct house in it 5 years prior to his death. From which it is clear that 5 years after the construction of the house of the plaintiff, the father of DW1 is dead. In spite of it, DW1 in her cross-examination has stated that her father died about 15 years back. Even though he died more than 25 years back, admittedly, the father of DW1 had 3 daughters and 2 sons through his first wife and 1 daughter through his second wife, that is DW2. When the father of DW1 had the responsibility of performing the marriages of 3 more daughters and 2 sons, the evidence of DW1 and 2 stating that even after the marriage of DW1, her father helped her financially to purchase sites and to construct house could not be believed, my lord. Para 30, my lord. The evidence of DW2 discloses that she has already sold the house situated at Tumkur and now she is residing with her daughter at Baragur, from which it is clear that DW2 is not having even a house to reside. DW2 in her cross-examination has stated that her husband has given sites to all his children. This fact is not forthcoming in the evidence of DW1. If the husband of DW2 had good income from his business and had given sites to all his children, there was no reason for DW2 to sell the house and take shelter with her daughter at Baragur. If the husband of DW2 is financially sound, he would have made properties at least for his wife. When it is suggested to DW2 that when the first defendant was residing with the plaintiff, she has vacated the house at Mysore. She has stated that since DW1 was residing alone at Mysore, she has vacated the house and started residing at Tumkur. On going through the evidence of DW2, it can be said that she knows nothing about the family matters of the plaintiff and the first defendant. DW1 has admitted that the plaintiff was residing with her in a house taken on lease at Mysore, and even her mother-in-law was also residing with her, and her son was doing business along with her husband at Mysore. And while vacating the house taken on lease at Mysore, PW2, that is the mother of PW1, also accompanied DW1 to Tumkur. Para 31. DW1 had no any independent source of income, either to purchase sites or to construct house. DW1 has not placed any materials to show that she had any independent source of income. Item number 1 of the scheduled properties coming in the name of plaintiff, and there is no dispute with regard to item number 1, and the same is in possession of plaintiff. The evidence of DW1 discloses that the plaintiff was running poultry farm at Tumkur. DW1 has stated that the plaintiff has spent huge amount towards the marriage of the daughter of his cousin brother Gangaram. The evidence of DW1 discloses that dispute arose between her and the plaintiff when the plaintiff had developed an illicit relationship with Sunita, who is the wife of Gangaram, and spending more of his income for her. This discloses that the plaintiff was and is having good income. Even after the returning from abroad, the plaintiff was running company in the house taken on lease for the benefit of the second defendant. And the same has been admitted by DW1. The plaintiff has proved that item number 2027 of the scheduled properties are his self-acquired properties. And the same has been purchased by the first defendant in her name, since he was working in abroad and visiting India once or twice in a year. But on the other hand, the defendant has failed to prove that item number 227 of the scheduled properties are her self-acquired property. Hence, the plaintiff, point number 2. The plaintiff has proved that he is the absolute owner of item numbers 1 to 7 of the scheduled properties. No doubt, the plaintiff has claimed a 3/4 share in all the scheduled property. But what is to be considered here is DW1 has led marital life with the plaintiff till 2011 for 34 years as per the evidence of PW1. And as per the evidence of DW1, she led marital life with the plaintiff for 24 years. In fact, DW1 has filed petition for divorce in the year 2011 against the plaintiff and has taken divorce against him. Since she was enjoying all the properties of the plaintiff, she has not claimed permanent alimony from the plaintiff. Admittedly, the first defendant is residing in the house of the plaintiff situated at Tumkur. Admittedly, the first defendant is receiving rentals from the portion of the house property. Plaintiff and the first defendant have led life till 2011 at Mysore. It is only in the month of April 2011 the first defendant has vacated the house at Mysore along with her son and mother-in-law and started residing in the town situated at Tumkur. The mother of the plaintiff was also all along living with the DW1, her sons and daughter, till DW1 filed a petition for divorce against the plaintiff. DW1 has performed the marriage of her daughter by sale of one of the scheduled properties and out of the lease amount. The evidence of PW1 discloses that his sons and daughter are not in cordial terms with him, but they are cordial with the DW1. Moreover, the plaintiff is ready to give 1/4 share in the scheduled properties towards the maintenance of DW1, even though the plaintiff is the absolute owner of the item number 227 of the scheduled property. Taking into consideration of the fact that DW1 has maintained the family well when the plaintiff was in abroad and was taking care of the mother of the plaintiff and also his brothers and purchased the properties out of the earnings of the plaintiff. The plaintiff is entitled to half share in item number 227 of the scheduled property, accordingly answer. My lord, my lord, my humble submission is that, my lord, whatever the trial court passes the order, the plaintiff accepts, my lord, and my humble submission to confirm the judgment and decree passed by the plaintiff.
It is not accepting. That is why an appeal. You accept, fine. You accept it, very good. Anything else?
Because it is from my earnings she purchased. Now I am on the street because they have enjoyed, they are enjoying. I am on the street.
So we have understood your argument. Main objection is that you are 70 years of age and on street and they should not enjoy. Yes, your wife should not enjoy. Because you are 70 years. Correct.
I accept the judgment and decree of passed by the trial court because 50% half portion will go to them. I accept it. That is my during my last stage of my life, at least I should have some protection. The judgment and decree passed by the trial court acceptable for me. Okay, they let them enjoy 50%. Let me have at least to survive myself till my death.
Can we ask them to accept or we have to decide appeal on merits? You have not answered any of the contentions raised by learned counsel for the appellant. You have just read the judgment and you are saying that you are accepting. We will say so, that you are accepting the judgment. That's why you have not filed an appeal. That is very clear. For that, you should have simply said, why did you read the judgment? You are accepting it. Correct. Fine. Anything else, Mr.?
See, he raised two pertinent questions. One is relating to jurisdiction. Another is contention that the person who is the owner of the property is not added as a party. Property is sold before the institution of the suit. Purchaser is not made a party. And according to him, under section 7, the sons are not the parties to the marriage. So the court has no jurisdiction in respect of the properties standing in the name of the sons. There is no answer from your end to this contention.
Ask him anything else he wants.
Yes. Is anything else?
I think what my contention is that whatever the trial court judgment is, that's what my.
Understood, yes.
Fine.
That's all. Yes. There is a suggestion to that.
we understand why he was yawning. That he is ready to accept judgment and decree. You are unnecessarily arguing. So he has lost interest in the appeal and was yawning. Learned counsel. Yes.
This is an appeal under section 19(1) of the Family Court Act, appealing the judgment and decree invoice number 32 of 2013 on the file of Family Court at the parties to the proceeding are the plaintiff, who is the husband of the first defendant, and the father of second defendant, second and third defendant. Who is third defendant? Father of the second defendant has filed the suit invoice number 32 of 2013, seeking a declaration, seeking a partition of suitable properties, and is claiming 3/4 share in the suitable properties on the premise that the suitable properties are purchased by him in the name of his wife, who is the first defendant. The other facts necessary for adjudication of the case can be summarized as the plaintiff has contended that he married the first defendant in the 1976, and he was working in Mangalore from 1990. Date of marriage 2/2/76, and he was working in Mangalore from 1976 to 1981, and thereafter he
74 to 81 Mangalore, MCF.
74 to 1980.
74 to 81.
Yes, understood. And thereafter he shifted to Libya and worked in Libya from 1981 to 1986. He has further contended that from 10/8/1991 to 31/4/1992 he was working in Qatar, and from 22/4/1995 to 4/5/1996 he was working in Dubai. It's also his contention that he was having a sound income when he was working abroad, and he has transferred the money in the name of his wife to purchase the properties, and the suit scheduled properties are purchased by the wife from the money transferred by him. It's also his contention that relationship between the plaintiff and the first defendant has got strained, and the first defendant is asserting her own right over the properties. As such, he is constrained to file a suit seeking partition of 3/4 share of the suit scheduled properties. He also intended that 1/4 share is to be given to the wife towards maintenance for having maintained the properties all these years. The first defendant wife and the second defendant son contested the suit. The contesting defendants have taken a contention that the suit before the family court is not maintainable in view of section 7 of the Family Courts Act. It's also the contention of the contesting defendants that the suit without the relief of declaration of title to the property is also not maintainable. In addition to that, the contesting defendants, the wife has taken a contention that the properties are purchased from her independent source of income, and there was no contribution from the husband, and the properties being self-acquired properties, the suit for partition is not maintainable. It is further contended that item number 7, which is sold to Natraj. Item number 5 now. It's also the contention of the contesting defendants that item number 6 property was sold on 9/9/2010. That is prior to the filing of the suit to one Mr. Natraj. And item number 4 property is transferred to the son of the first defendant, who is not met. Item number 4 property is transferred to Naveen, the son of the first defendant, on 26/5/2011. That is again prior to the filing of the suit. And Naveen is also not a party to the proceedings. It is further contended that item number 3 and 5 of the suit schedule are the properties transferred to the second son, Praveen, who is added as a second defendant, while gift deed dated 2/7/2011. As far as item number 1 property is concerned, the contesting defendants have admitted the fact that the property belongs to the plaintiff. And as far as item number 8 is concerned, it is the contention of the contesting defendants that the property was taken on lease, and by the time the suit is filed, the property is vacated and they do not have any right over the property. Based on the pleadings, the trial court has framed three issues. Please quote the issues. Page number 26. To substantiate his contention, the plaintiff has examined as PW1 and also examined PW2, his mother. Who is PW3? Brother of plaintiff, and his brother PW3, his brother PW3, and PW4. PW4, another brother of the plaintiff, whose evidence was later discarded as has not subjected himself for the cross-examination. Documents at Exhibit P1 to P27 are marked on behalf of the plaintiff, and the defendant number 1 examined herself as DW1, and her mother is examined as DW2. Documents at Exhibit D1 to D16 are marked on behalf of the defendants. The learned counsel appearing. Trial court, on considering the materials on record, has decreed the suit in part. No decree is passed in respect of item numbers 1 property and item number 8 property. The trial court granted a decree for petition of item number 2 to 7 properties, holding that the plaintiff is entitled to half share in the aforesaid properties. Being echoed by the aforementioned judgment and decree, the defendants number 1 and 2 are in. The husband has not filed any appeal in respect of the claim which is rejected by the family court. Or the learned advocate appearing for the appellant and the learned advocate appearing for the contesting response. Learned counsel appearing for the appellant would submit that the family court had no jurisdiction learned counsel for the appellant would submit that the suit for partition and separate possession without seeking a declaration of title that the plaintiff is the absolute owner of the suitable properties is not maintainable. It also is contention that the suit for partition is not maintainable before the family court, and the prayer seeking the 3/4 share in the suitable properties has no basis, and the finding of the trial court granting half share to the plaintiffs in the suitable property is again without any basis. And the properties at item number 3 to 6 were alienated prior to the filing of the suit. As such, the suit for partition is not obtainable without impeding the persons who have purchased the property or acquired the property before filing of the suit. The evidence led by the parties is also his contention that no evidence is led before the court to show that the properties acquired, the money transferred by the plaintiff to the first defendant. And in support of his contention, the learned counsel for the appellant has also relied upon the judgment of this court in the case of Kenu and others versus Jalabai and others. ILR 2009, Karnataka 612. The learned counsel appearing for the respondent would submit that plaintiff has produced enough materials to show that the learned counsel for the respondent would submit that by respondent, by referring to the reasoning assigned by the trial court from paragraph number 26 to 31, would justify the judgment passed by the trial family court, and would submit that for the family court has awarded
24 to Milan, from 24 onwards.
It's 24
Para 24.
31.
Para 24 to
Yes. 32.
That
32.
if except
32.
Yes, plaintiff is accepting the judgment, granting half share in social properties, though he had claimed 3/4 share in the scheduled properties. This is contention that the husband had sufficient income and he has transferred the same to the wife, and wife has purchased the property on the said end. We have considered the contentions raised before the court. The point for consideration is whether the appellant before this court are able to establish that the properties are purchased by the first defendant from her own independent income, and whether the second point, whether the family court is justified. Yes, yes. Whether the plaintiff is able to establish before the family court that the yes, that the properties are purchased by the first defendant from the funds transferred by the plaintiff. Second point, whether the family court is justified in granting a decree for half share in the social properties. We have considered the contentions raised at the bar. Also, there is the provision of law, namely Section 7 of the Family Court Act, and also the judgment relied upon by the And third point, whether the family court has got the jurisdiction to entertain a suit, claiming entertain a suit for partition filed by the plaintiff, where marriage, yes. Whether the
respect of by the respect of the suit by the parties, by the persons not parties to the marriage.
We have considered the contentions raised at the bar, and also there is the materials placed on record, and also the Section 7 of the Family Court Act. Since the point, one of the points for consideration raised before this court after the responsibility to jurisdiction of certain property.
Then first issue. The jurisdiction is first issue, right? Third one, make it one.
The Section 7 of the Family Court Act would read as under. Section second. The Section 7(1)(c). Section 7(1) explanation C would make it clear that the suit for partition before the family court is maintainable between the parties to the marriage, denoted comma, with respect to property of the parties or of either of them. Admittedly, in this case, there is no admittedly in this case, the second defendant, who is the son of the plaintiff and first defendant, is not a party to the marriage. Moreover, one of the properties which is transferred prior to the filing of the suit is sold in favor of one Mr. Nagaraj, who is not a party to the proceeding. This being the position, the family court does not get a jurisdiction to entertain a suit where the suit is filed claiming partition in respect of certain properties standing in the name of the second defendant. Were not parties to the marriage. On the records, it is explicitly clear that the properties bearing at item number 3, 4, and 5, 6 are the properties transferred prior to the institution of the suit, and those properties are standing in the name of the persons who are not parties to the marriage. This being the position, there is no difficulty in holding that the suit for partition in respect of item number 3 to 6 is not maintainable. The family court has not considered this particular aspect, and without referring to section 7 of the Family Courts Act, has erroneously proceeded to grant a decree for partition in respect of properties at item number 3 to 6. And according, therefore, the first point for consideration is answered in favor of the appellant, and the suit in respect of the aforementioned properties at item number 3 to 6 is set aside. Is held to be not maintained for want of jurisdiction. The judgment relied upon by the learned counsel for the appellant. Let's say that this is squarely applied. The judgment referred to by the learned counsel for the appellant in the case Hindu and others versus Jalabai, others referred Supra, squarely applies to the facts and circumstances of this case as far as item number 3 to 6 properties. Any of the finding given to finding point number 1 referred to above, this court is required to consider whether the plaintiff is able to establish that item number 2 and 7 properties are his self-record properties. Yes. As far as item number 1 property is concerned, the first defendant in her statement, in her written statement, has fairly conceded that the said property belongs to the plaintiff, and she has no claim over the said property. And trial court has also not granted any decree in respect of the aforementioned property. And as far as item number 8 property is concerned, it is borne out from the record that the property was taken on lease by the first defendant, and the first defendant has vacated the property, and as such, before the institution of the truth itself, as such, the trial court has not granted any relief in respect of item number 8 property. This being the position, the court is only concerned with item number 2 and 7 properties referred to in the plaintiff. The burden of proving the fact that item number 2 and 7 properties are the self-record properties is on the plaintiff. He must establish that he has transferred the money to his wife, and wife has purchased the property from the money transferred by him in his name, in her name. Though the plaintiff has produced records to show that he was working abroad, he has not produced any document to show that he has transferred the money to his wife to enable her to purchase the property. To enable her to purchase the property in her name. Stop. In the cross-examination, the PW1 has clearly admitted that he is not in a position to say as to when and how much money he has transferred to the name of the wife. He is also not in a position to say when and for how much money the wife has purchased the properties bearing at item number 2 and 7. He is also ignorant about the sale consideration amount, which is borne out from his own admission in the cross-examination. And Exhibit P17, the document relied upon by the plaintiff, which is the letter issued by the Canara Bank, to disclose that the bank has refused to divulge information relating to the bank account of the plaintiff between 1987 to 1997 on a query made by the counsel for the plaintiff under the Right to Information Act. There is nothing on record to show that the plaintiff himself has applied seeking information from this banker to furnish the details relating to the alleged transfer of amount from the his account to the account of the wife. Under these circumstances, the plaintiff is not in a position to establish before the court that he has transferred the money from abroad to the account of his wife to enable his the properties at item number 2 and 7. But it is not forthcoming from the records as to what was the expenditure incurred by the husband when he was abroad, and how much savings he has made, and how much money he has transferred to the account of the wife. Also say that the dependent is in a position to. Yes, yes, yes. Next one. Yes. Yes, yes. It is also required to be noticed that item number 7 property was purchased in the 1983 for a consideration of rupees 10,000 in the name of the first defendant. The original sale deed is produced. The wife has also produced the income tax returns, and in the income tax returns, which was filed at before the dispute arose between the parties, which are marked at exhibit B11 to D11 to D15. It can be noticed 16. It can be noticed that the wife has disclosed her income from tailoring as well as income from the rent, which she was deriving from item number 7 property.
It's still income
From tailoring.
from tailoring.
Yes. Since the sale deed pertaining to item number 7 property, which was purchased in the 1983, stands in the name of the wife, and as the property was purchased for rupees 10,000, this court can certainly hold that the wife has established her case that the property is purchased without the aid of the income alleged to have been transferred by the plaintiff. In the absence of any proof before this court that the income tax returns would clearly indicate that she had an income from her tailoring business, and the absence of any proof from the husband to show that he has transferred the money to the wife, this court can certainly conclude that the wife has purchased the property at item number 7 from her own income. And that being the position, it can be further concluded that wife had rental income from the said properties, which are duly reflected in the income tax records, and from her rental income as well as the income from tailoring, which is again reflected in the income tax records. It can be safely concluded that the wife has also purchased item number 2 property, which was purchased in the year 2006 for a consideration of rupees 60,000. Sorry, 2004 for a consideration of rupees 60,000. 25/3/2004. On appreciation of the materials placed on record, this court is the view that the plaintiff has not discharged the burden cast on him to establish the fact that the properties at item number 2 and 7 are his self-accord properties, or are the properties purchased by the wife from the income transferred by the husband. On the other hand, the materials on record would clearly establish that the wife had independent source of income to purchase the aforementioned 2 properties. Next one. The evidence led on behalf of the husband, namely the evidence of his mother and brother, would not support the case of the plaintiff, as the mother and the brother have pleaded ignorance in the cross-examination as to whether the money was really transferred by the husband in favor of his wife. In the absence of any proof relating to the transfer of money, this court is not in a position to accept that the husband has transferred the money in favor of wife to purchase the property in her name. Accordingly, the point number 2 is answered in favor of the against the respondent. White is able to
2 and 3 on the side.
2 and 3. Yes, it is also required to be noticed that the purchasers are not made parties. Purchasers who have purchased the property prior to the filing of the suit, purchasers who have purchased the property prior to the filing of the suit, namely Mr. Nagaraj and Mr. Naveen, are not made parties to the proceeding. Likewise, in that view of the matter also, the suit itself is effective. And this is one of the reasons to set aside the judgment and decree passed by the family court. What says?
For the aforementioned reasons.
For the aforementioned reasons, the judgment and decree passed by the trial court are to be set aside, and accordingly they are set aside. Consequently, the suit of the plaintiff is dismissed. Appeal is allowed.
What she to write IA seeks leave of the court to withdraw IA 1 of 23 dismissed as withdrawn, then arguments heard, judgment dictated in separation. Huh? Where is your colleague, Mr.? Huh? What preparation have you made since yesterday? Huh? Read the paper. Why were you not here? So that we can ask, we shouldn't ask any question to you. Huh? Huh? Other courts seeking adjournment, right? That senior is busy at court hall too. Huh? Withdrawal of the appeal. All of us. So what now? What's that? So if you had made an application for withdrawal of the petition itself, what survives in appeal now? What prayer? Huh. No. So no. You supposing if the appeal is dismissed, right? You cannot this thing value the property. You cannot carry out. Permitted to sell. What is the issue involved in this appeal? Yes, item 22. Learned counsel for, so we'll say learned counsel for the appellant submits that CA 123 of 23 was filed before the learned company judge. Sure, right? Company judge. All right, so learned counsel for the appellant submits that CA 123/2023 be listed for consideration before the learned company judge. The aforesaid submission has not been opposed by learned counsel for respondent in view of aforesaid late CA 123/23. But this is filed after disposal of the company application. What is the order, right? Past. We will hear you, not like transfer and all this. But where does it say that it was filed before company judge? 166 of 2001. Just a minute. All right. learned counsel for the appellant submits that he had filed company application number 123/2023 in company petition number 166/2001, which has wrongly been listed for consideration before this court. In view of aforesaid submission, CA 123/23 is dismissed as not pressed. Let the appeal be listed for on admission. What transfer this bit you, Mr. If you have to file a fresh in a disposed of matter, can you file this thing here? There's no question of transfer. You approach independently. We will deal with this thing issue involved in this appeal. Right. It has been recalled. He has understood that way. Yes, madam. What? Which order it has been filed against? Which order?
Says 2000.
Much has been awarded. Then what is wrong?
Yeah. 2000 per 3.
5,000 awarded. What's wrong with the order?
And directly responded to provide update of this 5,000.
Okay, Mr. This, yes, the criminal petition 472. You are the husband. Then you are seeking you are seeking enhancement, right? Very good.
I have started.
What is your claim? Why? Why? Huh? Salary. What is his income, monthly income? If the finding. Out of 24,000, he should give you 10,000 and starve. Is the argument. Half of any children, then has he married again? Then how many distinct children from his second marriage? But yes, so we are asking how many children from the second marriage? 13. The moment we will put question, I mean, this you will seek instructions, right? Very good. Don't seek time after 10 years to find out how many children, right? We will not adjust the case. Fine, go ahead. Yes, Mr. Go ahead, whatever you have to argue. It's very good, right? Call the client, whatever questions court puts, call her, make her answer. Why we should not hear her instead of you? Why should we hear you? If you don't know anything about the case, let her argue. Please argue. Please argue. Where is the funding?
Paragraph 11, page. Paragraph.
Mr. Sharif, obviously it appears that you are not ready with the matter, right? You are turning pages here only. Get ready. We will take it up tomorrow for further hearing. Please, your client is watching. You have no fear that your performance is being watched. Not ready with the case. What is this? And two counsels, both of them are like that. Very good. So, madam, what is we are asking him? Where is the finding recorded by the court saying that his monthly income is 24,000 rupees? That he is unable to point out. Point out, I mean, if you would have read it, Mr. You would have known that finding is in para 11. Tell us.
The magistrate have accepted the respondent has closed the garage and shifted the burden to prove the greater that much. He has exposed it.
Page 29 of which judgment? Are you referring to internal page number 29?
On television of the order, not to the
Running page. What is the running page?
internal page 90.
Running page.
68.
Internal pages are Mr. Paul.
On television, in the center mother. Television of the document produced by the creditor, it is seen that the respondent is the owner of property bearing 1637 for the as per the lower court have considered the other document exhibit 12 are related to the property, the terrace, to one property of Saraswati, the mother of the respondent, and that the respondent might other property, the after the he has the property. Yeah, that property that has to be. The garage is the commercial area. Anyhow, it is admitted by the respondent that the possession of the property. The garage. Is also admitted in the respondent is the whole document is gone.
Yes.
It is also admitted to the certainly will not so it is 15,000, 25,000 per month. This property is one property. The other property which was
Where is the finding 6 properties and is he deriving any income from 6 properties? His property. Is he deriving any rental income?
Yes.
25,000.
And that property has to be not the rented property. He is the owner of that property.
Nobody is saying that rented property. We are not concerned with his property, right? We are concerned what is the source of income so as to determine the quantum of maintenance. Simple, right? So until unless you are able to. So that is, he is earning, the court has said 15,000 to 25,000 a month. That we have understood. And there has to be, if he is having several properties, there has to be evidence to show that he is earning an income, rental income from that property. Like if he is residing in a house, just a minute, sorry, just a minute, we are asking, like we are telling you, supposing if the value of his residential house is 10 crores and he is residing there, so it is not no income from the house, he is residing there. Let it be 10 crores, doesn't matter. It doesn't matter. It's not a source of income. His source of income is, it's been determined 15,000 to 25,000. Fine. For you prepare, Mr. Whatever you have to argue, say, we will hear you tomorrow. You want to be clear, right? If you send it in children, I will send it. Here. But he has taken print. Yes, yes. Assemble tomorrow. See, all cases are being repeated. You tell him. Which case? With the other side. Right. Yes, madam, right. Learned counsel for the parties jointly submit that the dispute between the parties is likely to be amicably settled with the parties. And the parties are ready and willing to appear before Bangalore Mediation Center on such date as may be fixed by this court. Paragraph. In view of aforesaid submission, parties are directed to appear before Bangalore Mediation Center on which date? 17th June 23, Saturday. Why? You are not coming to court tomorrow, right? Huh? Coming tomorrow? No, but what's the urgency today, madam? If you want to argue, we can sit. There is a court function at 2 o'clock. We don't see any logic in restraining the court from getting up at you for your convenience. Why? He was referring for mediation. That's why we have passed an order. You want your case to be referred to mediation? Where is the other side? Do you want the matter to be referred to mediation?